It's rare for a client to be able to witness an attorney actually arguing a case before a court when a client is looking for his or her own lawyer. Back in 2003, I was approached to represent a man who had been unjustly convicted of first-degree murder back in 1990, and he served 16 years in prison for a murder he did not commit. I appeared before the Superior Court and convinced the Superior Court judge to grant my client a new trial. The DA's office actually appealed that granting of a new trial, and I wound up arguing before the Supreme Judicial Court of Massachusetts, arguing that my client should be granted that new trial. Here is the argument that I presented.
Mr. Yannetti.
Thank you, Your Honor. May it please the Court, my name is David Yannetti, and I represent the appellee in this case, Roland Douglas Finney, Jr. Your Honors, this Court should affirm the decision of a Superior Court justice and grant my client a new trial.
What are the connections between Mr. Barger, who you claim may be the third-party culprit, and the victim here that would warrant, for example, the Court permitting the admission of hearsay evidence?
Well, I think there are two answers to that. The first is there was substantial evidence developed that he had the motive, means, opportunity to commit this murder, and also acted like a guilty person would and demonstrated consciousness of guilt in the aftermath of the murder. The second answer to that, Your Honor, is that with regard to Mark Barger's statements that he made, which are really the only hearsay evidence that we're, or potential hearsay evidence that we're talking about here, I would assert that those aren't hearsay at all because they are not offered for the truth of the matter asserted. The connecting links, Your Honor, go to exactly what evidence we have that Mark Barger committed this murder.
But if what you say is true, then any time there is a nut within a couple of blocks of a crime scene, that person's conduct could be put to a jury as a potential source of a third-party culprit.
I disagree, Your Honor. Anytime there is evidence of a maniac down the street, 1 block away, it's in the record, just 1 block away, who has demonstrated through his statements that he knows the victim, that he
How does he know her? What was in the evidence that said that he knew about her?
Well, there was nothing in the evidence at trial, and the jury should have heard this evidence.
No. What was in the evidence at the motion for a new trial that he knew her?
Well, when confronted by his wife the next morning, or when she mentions the fact that there had been a murder of this poor girl down the street, he says she probably deserved it. Number one.
How does that indicate that he knew her?
That, in conjunction with the fact when she says, well, the paper is saying she was a really nice girl, he says she's not the goody two-shoes that they made her out to be. There was further evidence that the police received that a neighbor had also said that Mark Barger knew some girls from the college. The victim was a girl at the college. You take all of that into consideration, Your Honor, and that is powerful evidence that he knew her, disliked her, and wanted to see her dead. And take that into conjunction
That's powerful evidence?
Well, I would argue that to a jury, Your Honor.
Well, of course you would argue that to a jury. But what's the power in that?
Well, I think the power in that is once you take that evidence in conjunction with the fact that he had the means to commit this murder, he had that axe handle that he disposed of, that the police never looked at, and is consistent with the rod-like instrument that Mr. Kunis just spoke about. You talk about the fact that he had the opportunity to commit this murder, which is that his whereabouts are unaccounted for at 11:15 to 11:30 p.m. The medical examiner testified that the victim was found at 1:30 and that she would be expected to live for 2 hours or a little bit more with those injuries, which would put the murder at 11:15 or 11:30, which would, I would argue, to a jury, if given the opportunity.
Well, that's all very interesting, but how is it a substantial connecting link?
Well,
it really doesn't place him there.
Well, Your Honor, specifically with regard to this issue of substantial connecting links, please, that only applies to the statements that Mark Barger made. It does not apply to the axe handle evidence. It does not apply to his opportunity to go into that house and the fact that the door was unlocked. It does not apply to his consciousness of guilt in the aftermath of the murder. It does not apply to the fact that he fled the area 3 weeks later. It does not apply to the fact that he got rid of the axe handle and his wife never saw it again. And it does not apply to the fact that he washed all of his clothes for the very first time. Only time.
No, wait a minute. You said the only time he ever washed clothes?
Yes, Your Honor, the only time he ever washed his clothes after coming home from work.
I thought there was some reference to the wife's testimony that he had washed clothes before, but this night she was awakened because the washing machine was unbalanced, and that's what woke her up.
Your Honor, you're correct, except the evidence was adduced at that trial. The evidence was that during the 5 years that they were married, her estimate, 23 years after the fact, was that he may have washed his clothes once or twice per year. I put the question to her, how many times of those once or twice per year did he ever wash his clothes after coming home from the night shift? The answer was none. Take all of those into consideration, Your Honor, and my argument is that provides a substantial connecting link and a lot of circumstantial evidence that Mark Barger was involved here, which would justify the admission of hearsay. However, again, my argument is that those statements aren't hearsay at all.
Okay, so what you're saying, Mr. Yannetti, is whether or not that's powerful evidence, people could differ, but you should have had the opportunity to present it to a jury so the jury could have decided whether it was powerful.
That's precisely the point, Your Honor. That's precisely the point. In July of this year, Your Honor wrote an opinion, Como versus Cohane, which stated a long-standing rule of this Court, which is that a criminal defendant has a constitutional right, federal and state, to present evidence that someone else committed the crime.
Mr. Yannetti,
Yes.
let me ask you this question. This defendant's conviction was affirmed in 1993. This victim was killed in 1980.
Correct.
And we have a delay from 1993 until 2002 before he brings this claim.
Correct.
I think it would be reasonable to assume that it will be very difficult to retry this case. I don't know which witnesses are available. What, if any, attention should the Court pay to the long delay in bringing this motion for a new trial?
Very little, Your Honor, I would assert. I would argue to the Court that with regard to the Commonwealth's ability to retry this case, they would be in a far better position to do it than in other cases where their evidence depended on, for instance, eyewitness testimony, identification evidence, things of that nature, where they'll have to gather up their witnesses again and test their memory 20 years later. This case, as this Court has already noted, depends almost exclusively on a confession, an alleged confession, typewritten by police. That confession is still available. The police officers, I've seen them. I know that they're still around. That is the sum and substance of the Commonwealth's case. When this case was reviewed back in 1993, this Court, like the jury before it, was misled into believing that the confession is all there was and that there is no other suspect.